Hello folks, welcome to Wikipedia World. This is Abhinay Gupta. So today we'll continue with the topic, the compromises, arrangements and amalgamation of companies. And let me remind you, we will consider the provisions of Companies Act 1956 and not Companies Act 2013. Right? So, what have we seen in our previous lectures? We have seen the sections 391 to section 396. So we have seen the procedures for compromise and arrangement, the procedures for reconstruction or amalgamation by sale of undertaking, that was 394. We have also seen the reconstruction by sale of shares and takeover, which was section 395. And we had also seen that 395 was way different than 391 and 394, right? Because there was no intervention of the court. So these are small silly points that you need to remember that will help you understand the section and memorize the section number 2. Then we had also seen the amalgamation of companies in public interest, where two companies are amalgamated on the will of the central government. Right, that was section 396. Today we move ahead to section 396A. So it is a very small portion from the previous topic that was left behind. We'll complete it and move ahead to another section in 400 and 500 series, which may not be given in most of the textbooks that you follow for the teachers, but is indeed a part of your course and curriculum, and you have been asked questions on the same. So we'll be discussing those sections later in the chapter. So let us start with section 396A, that is preservation of books of amalgamating company. So whenever a company gets amalgamated with some other company, right, like company A gets amalgamated to company B and they form company B, it gets absorbed by company B. So company A loses its existence, loses its identity. So what is to be done at that point of time? So whenever something like that happens, the shares of the amalgamating company, the books of the amalgamating company have to be preserved by the company. They are not allowed to dispose such books of accounts unless and until they have taken an approval from CG. So there is no specific period that has been defined in this section. They just say that whenever you want to dispose it off, take an approval of CG. Right? Central government has the sole power to authorize the disposal of such books. And it can also be in the case where there is a company whose shares have been acquired by some other company. So even the company whose shares have been acquired, who lose their existence now, will have to maintain their books unless and until they are permitted by central government to dispose them off. Right? Now, we have seen so far that the disposal requires the previous approval of CG. Right? But what happens when you go to CG for approval? When you go to the central government for approval for disposing the books of accounts, the central government will appoint a person who will come to you and inspect. Right? They will examine the books and papers. And then they will decide accordingly whether or not you are allowed to dispose it. So what does that examiner do? What has he got to examine? Right? So we need to know what is the purpose for that examination. So the only thing that the central government wants to know with that examination, when he sends a person where he needs to decide whether or not you're allowed to dispose the books, is that they want to see whether or not you have committed any offense in the promotion, formation or management of the affairs of the company. They want to be sure that there was no fraudulent intention or fraudulent deed that were conducted, that were taken place. Right? Because there can be a situation where you form a company and indulge into some fraudulent deed into some malpractices, and then to overdo it or to camouflage it, you get amalgamated to some other company and then dispose the books off. That is a simple way to get out of it. Right? So CG stops you at that point. They say that if you want the books to be disposed, you will have to take our prior permission, prior approval, and then we will come and examine your books and identify whether or not something like that had taken place. Right? And if everything goes clean, yes, you are allowed to dispose your books. Right? So there are two areas where they will see for any fraudulent or unfair practices. One is in the affairs of the business that was being conducted before amalgamation, and the other is if you have gone into any malpractices or any unfair offense in the course of amalgamation or acquisition of share. Right? And then if they get a clean chit from there, yes, you are allowed to dispose your books and get rid of them. Right? So that is all that happens over here. That is all what section 396A talks about, right? The only thing is dispose of the books but take the approval of CG. So next section that we will take over today is section 494, that is reconstruction on the members voluntary winding up. Yes, you heard me right. It sounds a little difficult to absorb the heading of the topic, reconstruction on members voluntary winding up. When there is already winding up, how can you reconstruct? But that is the catch over here. Yes, when the members have passed a special resolution to wind up the company voluntarily, there may be any reason why the shareholders want to wind up the company. But when they pass a resolution and they have the authority, they have the approval from the court and everywhere, and they go on for voluntary winding up, even that is the time when reconstruction can take place, right? Now let's see how is that done. But that can be done by the liquidator of the company. So once you have your liquidator, you can just call him and he can do away with the procedures. He is the only one who has the power to reconstruct your company when you are winding up. Because whenever you go for a winding up, the court will assign an official liquidator to you. Now what powers does that liquidator have? Right? They have the power to transfer the assets or any property to another company, which is the transferee company. Right? And in exchange of that, as a consideration, they will take the shares or the other securities of the transferee company. Right? It can also be cash, whatever consideration you want. The liquidator can demand for cash settlement, for share settlement, for any other kind of consideration. Right? So this is the power given to the liquidator. They can sell off the company, like give it away to some transferee company and take the shares or cash or consideration and then distribute that consideration amongst the shareholders of the company, of the transferor company, the company for whom the liquidator was appointed. So over here, even the cumbersome procedure for winding up comes to an halt, and that is an easier procedure to sell off the entire company, right? To reconstruct the company into some other name, to give it away to somebody. Because when you go on for winding up, you have to dispose of all your assets, settle down your liabilities, pay your workmen, your employees, your creditors, and then if something is remaining, you get it to the shareholders get it back. You again call the contributories and stuff. The details of winding up we'll see in the chapter of winding up. Over here what we say is okay, we'll avoid that cumbersome procedure of winding up, and in short we will dispose away the assets and properties of the company by giving it away to the transferee company, and in exchange we'll take the shares and settle down. Right, so that is the power given to the liquidator in this case. So for reconstruction on members voluntary winding up, there are three specific things to keep in mind. One is that the company should be in the process of liquidation. That means you should have an official liquidator assigned to you, because he is the only one who will take the procedures ahead, right? Second is that winding up has to be done voluntarily by the shareholders by passing a resolution, a special resolution in the meeting, right? And third, that there is no specific power in the memorandum that is required to undertake this activity. Because obviously when you form a company, you don't think about winding up, right? And even if you know, or if you have plans of winding up in future, you don't think of reconstructing it in the process, right? Because that cannot be planned in initial when you start the company, because you think of long term, you think of taking it ahead. So there is no specific provision of mentioning it in the memorandum in the very beginning that okay, when we are winding up, this is what we can do. No. Even if it is not mentioned in the memorandum, you can go ahead with it. It is just about this specific situation where it can be done, right? So now let's move on to the procedural part of how will the liquidator go ahead with the procedures. So to start with the stage 1, the shareholders will pass a resolution for voluntary winding up. They'll call a meeting of the shareholders and pass a resolution. Okay, now we are gonna wind up the company. And that will obviously have to be a special resolution. Then the liquidator of the company who has been assigned after the company undergoes voluntary winding up can enter into an agreement with the transferee company. Like they will settle down with the terms and conditions and enter into an agreement. Okay, I will give you the properties and the assets of the company, and in return what you will give me is the share or cash or any other consideration, whatever they deem fit. But again, the liquidator does not have the sole power in this case. They will have to be authorized by the members by passing a special resolution, right, when they enter into an agreement. Without the consent or without the special resolution from the member, the liquidator cannot enter into an agreement with the third party, with the transferee company. Right? Because it is the company's assets, the company's property. Liquidator is the third person who has come for the liquidation purpose, who will settle down the assets and liabilities and then dissolve the company. Right? So they cannot straight away go ahead and deal with the transferee company. Okay, you keep the properties and give us the share. No, if the shareholders are ready to take the share, then only the liquidator can go ahead and give it to them. Right? So once the agreement is done, now the procedure begins. Stage 3 is the transfer of whole or part of the business of the property. It is as per the agreement. Whatever you have decided, whatever the transferee company has settled down in the agreement, that is how you proceed forward. So now once the agreement is done, you give away the property or give away the assets, right? You transfer it to them, to the transferee company. And then you get the consideration. The transferee pays the compensation in form of any shares or any cash or in any other form, whatever is agreed in the agreement again, right? And this is given to the liquidator. The transferee company has no direct interaction with the transferor company. They have an interaction, they have an agreement, they have a bond with the liquidator. So when they take the property and asset, they give away the share or the cash or whatever it is to the liquidator. And then it is the duty of the liquidator to pass it on to the shareholders of the transferor company. So that is a small circle. That is the procedure in 3 simple steps. Pass a resolution, get into an agreement, give away the properties, take the share and give it to the shareholders. Finish. It is as simple as that. But this can be done only when the company is undergoing a voluntarily wind up, that too the members voluntary wind up. It is not the creditors voluntary wind up. We will see the creditors voluntary winding up in the next section, where you will have a little modification in the power of the liquidator and rest of the things will remain same. So that becomes an easy task for you. You get to learn a whole new section, which again has appeared in your examinations earlier, and you don't have to mug up anything else. It is just one understanding that you have taken in this section that will be carried forward in the next section, and instead of the shareholders you'll have the creditors, right? So now over here, whenever you pass a resolution, okay, this was a special resolution, right? We say ki, okay, the agreement will be done only when there's a special resolution by the members in the meeting. But even when there's a special resolution, it is not 100% resolution, right? There are some shareholders who will be dissenting it, who will not agree, right? Now what will happen if there is some shareholder who objects to it, who objects to the agreement, who is not willing to give away the properties of the company for the shares or for the because the price of the shares are also fixed. Maybe that shareholder is not willing to give away at that amount. He is not convinced with the consideration he's getting. So he is a dissenting shareholder, right? Who does not agree to the resolution passed in the shareholders meeting. And if there is some shareholder who were not present at the meeting but still wants to object to it, so what can they do is, if they want to express their dissent from the agreement, they will have to give a letter in writing at the registered office within 7 days of passing the special resolution, right? And these people will be clubbed in the category of those people who were present in the meeting but dissented to the resolution, who didn't agree, who didn't support the resolution, they were against the resolution. So these people clubbed together will have a settlement with the liquidator of the company, right? So the dissenting members may require the liquidator either to abstain from carrying on the resolution. They'll say, no, although you have a special resolution, we won't allow you to go ahead with it. You cannot simply give away the property and give us the share that we don't agree, right? Or in other case, they can also, the liquidator can purchase the shares of the dissenting shareholders. The liquidator will say, okay, you don't agree to it, give away your shares, I'll be the shareholder now and I'll go ahead with that. You want some consideration for that share, bid a price, settle it down and take it away, right? It goes that way. So over here, when you have the dissenting shareholders at one hand and the liquidator on the other, they will bargain among themselves. Okay, you give me your shares, I'll be the shareholder now. You move ahead, step back, and you take the consideration. Now that price for the share will be decided amongst the liquidator and the dissenting members itself. And if there is a dispute, for example, if they're not able to settle down at a price, Maybe the liquidator says, okay, I'll give you X amount, and they are saying, no, I want 2X amount. So there is a conflict which cannot be settled because there is no third party involvement. So what do we do when we need to settle down a conflict between two people? We involve a third person. Now that third person will be an appointed arbiter, right? And with the mutual consent, he will decide what will be the price of the share. And where the liquidator plans to purchase the share of the dissenting shareholders, instead of abstaining from carrying on the resolution, they plan to, okay, we'll purchase the share. Then the purchase consideration, the purchase money, shall be paid to the dissenting shareholders before the dissolution of the company. You can't wait, okay, let the company be dissolved and we'll make you the payment. No. If you want to make them a payment, if you have settled down at an agreement, okay, we'll take away your shares and give you the consideration, then do it then and there before the dissolution of the company. Settle them first. But how will the liquidator give him the money? Because he's not selling away the properties anywhere. He's giving away the properties to a transferee company in this case. It is not a winding up, normal winding up where they sell away the properties and assets and then get the money and pay off. So whatever be the mode of raising the purchase money, that will be decided amongst the shareholder. Again, by passing a special resolution. Because you will have to pay the dissenting shareholders. So from where will the liquidator get the money? So that mode of earning the money to pay off the shareholders will be decided by the shareholders in the shareholders meeting by passing a special resolution, right? So that is the entire procedure that takes place, right? And that is how we tackle the dissenting shareholders. So these are two basic points, two basic understanding that we need to have under section 494. And I think it is crystal clear with you guys now. You understand how things go on. It is not about the text that we are talking. It's about a situation that we have created and how we deal with it. Right? We have seen it in steps. Now there can be one more challenge, one more condition. Right? We already know that it has to be a voluntary wind up, and that too a member's voluntary wind up. It is not about the winding up that the court has ordered. Right? So if at any point of time, right, like somewhere in the past 1 year, if the court had ordered winding up, which was not carried forward or which was settled, and then within 1 year the members call for a winding up, right? So in that case, there is something fishy, because if the court had asked you to wind up the company 1 year back, within 1 year, with like 3-4 months back or 8-10 months back, you didn't go ahead with it. You didn't want a winding up. Again, suddenly in 10 months you say, okay, we'll wind up. So there is something fishy in that. Right? So that is not a very normal situation, not a very normal condition, not a very normal phenomena that occurs. So in that case, when something like that occurs in the procedure, then you will also have to take the permission from the court. So the special resolution that you pass shall not remain valid unless it is sanctioned by the court. Right? That is another one restriction that can be again case specific. So that was one point I needed to discuss, and we have done with it. So here we complete the entire section, that is section 494, which is reconstruction of the company, which is being wound up by the members on a voluntary basis. Now, when we started this section, we made it very clear that this is a winding up, voluntary winding up by the members. Now, what if the creditors want to wind up the company? Right, that will not be dealt by section 494. That will be covered by section 507, right, where it is the reconstruction on the creditors' voluntary winding up instead of the members. So over there also I had told you, here I'll just repeat it, that over here the entire procedure will remain the same, and instead of the special resolution by the member, you will have the creditors who are approving the winding up. Everywhere where the members were involved for special resolution or for dissenting and stuff, the entire procedure, that if you had a plot, from that plot, members have been removed and creditors have been inserted. Rest, the liquidator, court and everywhere, they remain the same. Now the liquidator will not seek an approval from the member, he will seek an approval from the creditors. Right? So there are two specific points that I would like you to know. We'll just wind it up quickly and cover up with the lecture today and move ahead with one more remaining topic in the next lecture. Right? So what we need to see is now the modifications. So the only modification basic over here is that the power of the liquidator, which was specified under section 494, shall be exercised only with the sanction of the committee of inspection or the court, right? So now there are two people who can authorize the liquidator to go ahead instead of the members. It will be the committee of inspection or the court. Now with this we come to the end of the section, which was section 507. There was just a simple modification where instead of the shareholders, you will have the sanction of the committee of inspection or the court, right? Now, there's one more important thing to keep in mind, which is that the transfer of the property and asset that we have been talking about in the entire chapter can be done only to a company. We have used the word the transferee company, so it has to be a company. It cannot be any other person or the trustee of any company which is yet to be incorporated. Right? It has to be an incorporated company registered under the Act. Right? I'm giving you out this specific point, because you can be asked a question on that. That can be a Google in the examination, and you also have a case study based on the same thing, right? Which was referring the irrigation company of France. So it is very specific to understand it is about a transferee company, not about any other person or a trustee of any company who is yet to be incorporated. Right? So with that, we'll wind up the lecture today. In the next lecture, we'll continue with the last section, section 517. So until then, this is Abhinay Gupta signing off. Goodbye. Thank you.